Hello all, welcome back to Columbia College's business law class. My name is Cassandra Jenneke and I'll be your instructor. Today what we're going to be doing is going over the second and third elements of a valid and enforceable contract. So just as a reminder, last time we were here we talked about the first element of a valid and enforceable contract, which is an agreement. That is comprised of an offer and an acceptance. That agreement, when entering into a contract, must be between two competent parties. So today we're going to be talking about capacity and competency. And it must be based on the genuine assent of those parties. So contractual capacity is actually very broadly defined. So contractual capacity means that you as one of the parties in a contract has the ability to understand that a contract is being made and what its general meaning is. Contractual capacity is not complete and total in-depth knowledge of every single term in a contract. Contractual capacity does not mean that you as a party to the contract have to understand the contract's full legal meaning. It just means that you have to understand that you are entering into a contract and what its general meaning is. Because that definition is so broad, everyone, if you were to take a case to court about a contract, every person who enters into a contract is presumed to have capacity. So what that means is if you want to come in and say, hey, listen, judge, I lacked the capacity to enter into this contract, you should let me out of it. You will have to show that you lacked capacity at the time you entered the contract in order to prevail on that issue. There are two different types of capacity. The first is status incapacity. Status incapacity applies to classes of people that because of some factor within them, we as a society recognize that they lack the ability to have contractual capacity. Contrast that with factual incapacity, which exists when a person is not able to understand that a contract is being made or is unable to understand the general nature of the contract because of some mental condition that's either caused by age, mental illness, medication, drugs, or alcohol. So status incapacity is because of who you are as a person. Factual incapacity is because of something you suffer from as a person. So minors and age, being too young, is really the only remaining status incapacity that we utilize in the law. It used to be that women couldn't enter into contracts, blacks couldn't enter into contracts. We have eliminated those as status incapacities, but we recognize that folks who are young, specifically under the age of 18, are unable to legally understand the consequences of entering into a contract, and so we find that they are incapable of having capacity under the age of 18. So a minor is somebody who's under the age of 18. That's pretty simple, right? But a minor, when they enter into a contract under the age of 18, they have the option of avoiding the contract. What does avoidance mean? Well, that means that a minor may disaffirm by any expression, so verbal, written, or act that is inconsistent with continuing the validity of the contract. A minor can affirm or ratify the contract once they become an adult in three different ways. When we talk about avoidance, this is a right that is held only by the minor. So the minor, before they turn 18 and for a reasonable time after they turn 18, they are the only ones that have the option to avoid or undo the contract because of this status incapacity. So as I mentioned, the minor can disaffirm during their minority, so before they turn 18, or for a reasonable time after they attain majority, which is turn 18. After that, a contract is deemed to be ratified and cannot be avoided even if the person was a minor at the time that they entered into the contract. Now, I hear some of you saying to yourselves, well, hey, Cassandra, that is not fair. What if the minor lied about their age? How am I supposed to check that? What am I supposed to do about that? Generally, when a minor lies about their age, it does not affect their ability or power to avoid or disaffirm the contract. Some states will hold that fraud of a minor regarding age can bar avoidance, and basically what that means is, let's say a minor goes into a car dealership and provides a fake ID. They enter into a lease agreement to lease a vehicle, and come to find out the driver's license is fake, the kid was 16, and didn't even have a validly issued driver's license. That fraud, that lie, some states will hold disallows a minor to avoid their contract. You entered into it with bad intentions. Now you don't get to get out of it simply because that's what you lied about, right? You lied about your age. Now, some states have kind of a hybrid model, right? So we've got some states over here where it doesn't affect a minor's ability to disaffirm or avoid the contract at all. Then you have folks on the other states on the other side where they're like, no, listen, if a minor lies about their age, they don't get to avoid the contract because they were minors at all. That fraud bars avoidance. And then you have folks in the middle who will allow the minor to disaffirm the contract, but will require the minor to pay for any damages to the property that they received under the contract. That's an important distinction because when a minor avoids a contract, they're not on the hook for any, typically any damages that happen to the object of the contract. How crazy is that? So where the original consideration or the object of the contract is intact, then the minor, upon avoidance or disaffirmation, must return what was received, or at least offer to do so, right? So they have to put the parties back where they were in their original position before the contract happened. However, if the original consideration is damaged or destroyed, then the minor still gets to disaffirm, still gets to avoid the contract, and only has to return what remains, even if there's nothing left to give back. So, Cassandra's rule of contracts number 2. Do not enter into a contract with a minor. Ever. Never. Not once. If you think somebody is underage, don't do it. Avoid it at all costs. Okay? So, the minor holds all the cards in these situations, which also means that you as the other adult party have to give back what they gave you in the first place. If the property was sold, then the minor gets to receive the money from the original party, but has no right to the actual object to bring it back. Now, one exception that we recognize for contracts with minors are contracts for necessaries. These are things that are indispensable or absolutely necessary for the sustenance of human life. So we've had some recent expansions on this. I mean, very typically what we see are contracts for food, shelter. Recent expansions have included health insurance, okay? Minors can disaffirm contracts for necessary items, but they have to pay for what was furnished to them. And the reason that we have this exception, this blanket exception, is it's a public policy argument, right? We want people to offer and to give minors the things that they need to live, okay? But we also recognize that that's a great risk to these other folks if they know that they're minors, right? Or even if they don't know that they're minors. So in order to protect those folks that are going to provide necessaries for minors, we tell them, hey, look, the minor gets to disavow, the minor gets to disaffirm the contract, but you won't be out without any payment. Now, I've had many students in my class ask me, hey, well, what about parents? What about guardians? Well, when a third party gives parental services to a minor who has a need for that, then the minor will not be liable because the contract will be with the parents and not the minor. Okay? So if you're, like, let's say, for example, you have a parent who co-signs a loan for a vehicle for you, you're 17 and they're 18. The contract really isn't with you, it's with your parent. So they're going to be on the hook, not you as the minor. Now, I mentioned ratification, and basically what this means is that, listen, parties can enter into contracts and can successfully complete and perform contracts that may have a reason to be disaffirmed or avoided, or that maybe aren't enforceable because it lacks one of the 6 elements of a valid and enforceable contract. The only time it becomes an issue is when somebody makes it an issue. And so, for example, if a minor enters into a contract when they are a minor, they turn 18, and a year passes, they're acting like a contract exists. Guess what? A contract now does exist because by their actions or lack of actions, they have ratified what would have been a voidable contract at the minor's option. So, a former minor cannot disaffirm a contract that has been ratified after reaching majority. Ratification are any words or conduct that manifest an intent to continue to be bound by the contract. So some states will require that ratification happen in writing. California is not one of them. And when we talk about how long until a contract is ratified by a minor, it's a reasonable time. This will be one of the first, but definitely not the last times we talk about what's reasonable. The law doesn't like black and white rules. So oftentimes you will hear, you will see, we will read that a lot of these laws are based on what's reasonable. And it's going to be reasonable based on the nature of the relationship between the parties, the nature of the contract itself. One day might be reasonable and 1 year might be reasonable. It's really going to depend on the circumstances. So if you come across an essay question or a question in your book that mentions one of the parties' ages and they happen to be under the age of 18 at the time that they enter into a contract, you want to talk about how that status incapacity affects that contractual relationship. And if that person was under 18 at the time that they entered into the contract, but are now 18 years old or older, you want to talk about whether or not ratification has happened. And that's going to be a conversation about what's reasonable. Now, there are certain types of contracts, much like when we get into bankruptcy law, some areas where states will say, hey, listen, you don't get to avoid these particular types of contracts. So my favorite, because they have like what must be the best lobbying folks known to man, are educational loans. So if you as a minor take out an educational loan, you're on the hook for it, and it doesn't matter that you were a minor at the time you entered into it. Most banks, if it's a private bank or a private organization that you're taking a loan from, they're not going to let you enter into an educational loan contract before you turn 18. But the federal government, speaking from experience, will let you go into all sorts of debt as a minor for an educational loan. Now, ordinarily, as I mentioned, parents are not going to be liable for the minor's contracts, but can be if the child was acting as the parent's agent. And typically a cosigner is going to be bound independently of the minor. And so if you have a cosigner on a loan, that person's going to be on the hook as a cosigner, regardless of whether or not you make payments or not. Okay, so that's really the only type of status incapacity that we still utilize in American law. But what we recognize is that there are all of these instances where people can, at one point or another in their lives, lack capacity. And so here we talk about mentally incompetent folks. So typically, if somebody is incompetent by virtue of a mental disease or defect, so somebody has Alzheimer's or somebody is schizophrenic, any one of those things, the effect of that incompetency allows that person to avoid the contract in the same way that a minor can. So if somebody becomes or is diagnosed with some sort of dementia, that person during that illness will lack the ability to understand that a contract is being made and what the general terms are. Some folks, by virtue of a mental disease or defect, may come in and out of capacity. They may have competency at one point and then lose it in the future. So once a person who was incompetent and entered into a contract while they were not competent becomes competent, they have the option to either ratify the contract, so keep going with it, act like contract's good, or they can disaffirm it. We typically will treat contracts as binding where the terms are reasonable and beneficial to the incompetent person, because we recognize that some folks won't ever be returned to competency, and so we need them to have contracts in place for their care, for people to help them with things. And so that's one kind of exception to that rule, is that if a person doesn't regain competency, they can remain bound by contracts. But that rule kind of butts up against what happens when a guardian is appointed. So if a court of law appoints a guardian for somebody because they lack the capacity to take care of themselves or a danger to themselves or others, then the contracts that are made by the incompetent person before the appointment of the guardian can also be ratified or disaffirmed by the guardian. However, if you enter into a contract with an incompetent person after they have a guardian appointed, so you go around the guardian to the incompetent person and make a contract with the incompetent person, that contract is void. We recognize that that is a shady thing to do, and it violates public policy, and so that contract will be void. Now, intoxicated folk. So I will say this. You have to be so drunk or high. Like, the degree of intoxication has to be so extensive that you do not understand that a contract is being made, okay? And you do not understand the content of that contract, the general terms of that contract. It is going to be really difficult to prove that you were that drunk or that high, okay? There's a great example, a story from the early 1920s about a gentleman who had been in the process of, who had these neighbors that he had refused to sell his land to multiple times. So they see him at a bar and they buy him a couple of rounds, and he enters into a contract written on a paper napkin that says, I will sell you this land for this amount of money. He comes back and says, no, that's not a valid and enforceable contract because I was intoxicated. But here's the deal. He wasn't that intoxicated because they bargained. They had multiple drafts of paper napkin contracts, and they all signed it. And the next day, he understood that he had entered into a contract, and he had haggled and bargained the terms. So to that point, you have to be damn near blackout in order for intoxication to void your contract. Now, sometimes parties will enter into contracts, and they will enter into contracts with mistaken beliefs. And so when we talk about mistake, deception, lies, pressure, what we really start to talk about is this concept of genuine assent. So when you think about capacity, the person that's entering into the contract, right? They're either a kid, so they don't know any better. They either have a mental illness that makes them unable to understand they're entering into a contract, or they're so drunk or so high that they don't understand they're entering into a contract, okay? It's the internal understanding. Juxtapose that with the concepts of mistake, deception, and pressure. these are really genuine assent concepts. And that's because while you may understand that you're entering into a contract and you may think you know the terms and conditions of the contract, there may be some external information that you are either mistaken about, don't know about because somebody lied to you, or you aren't entering into a contract because you want to, but because you're being forced to, right? And so that is where the concept of genuine assent comes into play. I am genuinely wanting and able and knowingly walking into and joining in this contract with you. So let's talk about mistakes. Two different types of mistakes. There's unilateral and bilateral, so we'll hit unilateral first. Unilateral is kind of what it sounds like, okay? So a mistake of fact that is made by one of the parties, that's a unilateral mistake. Start there. So one person makes a mistake about something that's fundamental to the contract. Here's the deal. That mistake is not going to affect the validity or enforceability of the contract when the mistake in the facts is unknown to the other contracting party. So if there was something that I didn't know about a vehicle that I was selling you that you found out after you bought it from me, I didn't know about it, so that's a mistake on you, so that's not on me, and we still have a contract. However, if I did know, or I should have known about the mistake, then the party that made the mistake, the unilateral mistake, can avoid the contract. Then we have bilateral or mutual mistakes. They can be called either one. They are synonymous names. Two parties who enter into a contract that are under a mutually mistaken understanding concerning a basic assumption of fact or of law on which the concept is made. That's the definition of a mutual mistake. We both thought we understood something, but turns out that we were wrong. And it's a basic assumption of fact upon which the contract is made. So, the contract is voidable by the person who is adversely affected if it has a material effect on the agreed exchange. So you'll see here on the screen that I've bolded mutually mistaken, a basic assumption, adverse effect that is material. Each one of those things has to be present in order for a contract to be voidable or avoidable under a mutual mistake theory. So, mutual mistakes in judgment do not avoid a contract. Let me give you an example. So, Sherwood versus Walker is a case from 1887, and basically what happened was Walker sold Sherwood Bessie the cow. Bessie was believed by all parties to be barren, unable to birth little baby cows. So Walker sold Sherwood a barren dairy cow. For those of you that don't know, cows that can't reproduce additional cattle come at a cheaper head price than those that can produce offspring. And so Walker sells Sherwood, Bessie the cow. Sherwood takes Bessie all the way back to his farm. Come to find out, Sherwood finds out that Bessie the cow is not barren. She pops out a new calf, and Walker's like, hey, listen, you owe me money for that because you got a super good deal when we both thought that she was barren. We were mutually mistaken about a basic assumption upon which the contract was made. I am adversely affected because I didn't get an appropriate amount of compensation for the cow that you received, and this has a material effect on our agreed upon exchange. So, this case goes through the court system, and the Michigan Supreme Court comes back and says, hey, listen, he's totally right. You either have to pay him the difference between a barren dairy cow and a producing cow, okay, a cow that can have little cows, or you give her back and he gives you back the money that you paid out for the dairy cow. Okay? Contrast that with horse racing, okay? Horse racing is a little bit different because some horses can perform better under certain circumstances with certain people surrounding them. It isn't simply that there is a biological inability to perform, right? Because that's what we thought we had with Bessie, a biological inability to perform. Contrast that with a horse that's doing okay, not the fastest, isn't performing well with its owner, not getting along with its trainer, so they decide to sell it. They sell it to another family on another farm with a different trainer. Come to find out, horse runs great, races great, starts making tons of money. They don't get to come back and say, hey, give me back that horse because look at how awesome it's doing with you. That is not a biological inability to perform. Rather, you made a judgment error. Okay, see the difference? Some folks have an issue with seeing and feeling these differences. So if you have an issue with that, bring it up during our lab and we'll talk more about it. Now, sometimes you can also just make mistakes in how a contract is transcribed or printed. So if you make an oral agreement that you then commit to a writing or a printing, and you inadvertently leave out a piece of the oral agreement on the final signed contract, the person who is aggrieved can petition for what's called reformation to adequately reflect the true intent of the parties. The burden of proof here is clear and convincing evidence. So you have more likely than not, which is a preponderance of the evidence. That's typical civil standard. And then you have up here, all the way at the top, beyond a reasonable doubt, which is what we utilize to take away somebody's freedom. And then we have here somewhere in the middle, this proof of clear and convincing evidence. Don't sign, this is rule number 3, do not sign a contract until you've read it. Because here's the deal. Courts don't want to reform your contracts. They assume, for the purposes of moving forward in a contract, that if you signed it, you read it. And so mistakes are going to be on you. So you don't want to be showing up asking for reformation because courts are not going to be very sympathetic, and you have a heightened burden of proof, which means you're going to need some other kind of writing to show that that was the true intent of the parties. You're going to need multiple people that were there to say, hey, listen, that was the true intent of the parties. That is harder to do, and our prove it folks are going to be like, shh, prove it, right? So do not, rule number 3, do not sign a contract that you haven't read. Now, another way that, so genuine assent can be affected by mistakes of fact, okay? Here, though, what we're talking about are not just simply mistakes, but when people deceive others that they enter into contracts with. So fraud. If you think back to our course learning objectives, learning the elements of fraud is number 2. So we're hitting them early, guys. So the elements. In order for you to be or to prove an allegation of fraud, you have to show, 1, that there was a material misrepresentation of fact. If it's not important to the contract, it's not fraud. Okay, so that's what material means. It means important, forms one of the bases for the contract. Just because you said something was white and it turned out to be gray, chances are, unless that's a material misrepresentation of fact, that's not going to be fraud. So a material misrepresentation of fact with knowledge of its falsity or reckless indifference to the truth, you say and intend that the person who's hearing the material misrepresentation of fact will rely on that falsity. There is actual reliance by the listener, and as a result of that falsity, that person suffers a harm. Okay? Now, statements of opinion or of value will not be regarded as fraudulent unless the speaker knows of facts that make the opinion false. So be very, very, very careful taking people's opinions or values at face value, because unless you can show what that person knew and what that person was thinking at the time they offered the opinion or made the valuation, that's not going to be fraud. So do your homework. That's rule number 4. Now, when we talk about reliance, we recognize that we live in a society where people are big talkers, okay? Sometimes we recognize that there are exaggerations made every day. And so lies or fraudulent or false statements will not matter unless the person reasonably relies on them. And so if a statement is so extravagant that a reasonable person would not rely on it, that's not fraud, okay? Proof of harm must be related to the falsity. So there has to be some nexus, some connection. Just because you were harmed doesn't mean you were harmed by the falsity. So you have to prove how those two things interlink. Now, I don't know about you guys, and I may have said this before, but if I was a mind reader, I would be doing something different with my life. And so one of the hardest things to prove in fraud cases and fraud causes of action is the concept of intent. Unless someone tells you, hey, listen, here's my intent in my actions, how do you prove intent, right? Where are my prove it people? They're like, psh, you don't know what I'm thinking. You don't know what I know. And it's true. That's really hard to prove. And so what we end up looking at is circumstantial evidence, right? You look at all the surrounding circumstances and you say, listen, is it more likely than not that they intended to defraud me? Yes or no. And so because that little piece is hard to prove, what you will often see is a fraud allegation coupled with a negligent misrepresentation allegation. Remember when we talked about negligence, right? Duty breach, cause harm. It's much easier to show that somebody owed you a duty to be honest and to tell you the truth, and that they breached that duty by being negligent in their representation. So maybe it wasn't necessarily a lie to them, but they didn't do their homework. They didn't fact check, and they just told you something without actually checking to see whether or not that was the truth, okay? That is a cause of negligent misrepresentation. And so these will, as I mentioned, be coupled with our intentional fraud allegations because negligent misrepresentation is oftentimes just easier to prove. Now, non-disclosure. If any of you have ever purchased a home, you'll know a little bit about non-disclosure agreements, right? But when we talk about contracts, we recognize the power and freedom of contract, right? And so the general rule is that you have no legal obligation or duty to disclose any information to another party if they don't ask you about it. If they ask you about it, you can't lie, but if it's for an unknown defect or condition, if you don't know about it, how can you tell them about it? Well, we do recognize an exception to that general rule for unknown defects and condition. If it's a condition that's known to the seller, unknown to the buyer, and it's one that the buyer is unlikely to discover before finalization of the contract, you have a duty to tell them about it. But if you don't know about it, you don't have to tell them about it. If you are in a confidential relationship with another party, you have a duty to tell them. Failure to disclose may constitute fraud. And you don't have the option of actively concealing something from another party. So basically, you have to not know about it, not be in a confidential relationship with that person, and don't actively conceal it if you do know about it. And if they ask you about it, don't lie. Now, so mistake and deception can affect whether or not a person genuinely enters into a contract, okay? The last way that your genuine assent can be affected is by pressure. And so we recognize two different types of pressure. The first is undue influence. And the concept of undue influence is really person-to-person relationship based. If you have a relationship with another party in which you exert some sort of dominance over that other person, there is a good chance that your influence, okay, can overcome a person's genuine assent into a contract. We presume that the dominating person is the one that obtains a benefit from the contract. So let's say you're like a lady in her 90s, and you have one family member still living, and it's a nephew. And your nephew calls you and he's like, "Hey, auntie, listen, I need $25,000 to buy a car, and if you don't give it to me, I'm not going to come visit you anymore at the nursing home." Number one, you're a terrible person. But number two, that's utilizing undue influence, applying pressure to the other party by virtue of your relationship, okay, and your knowledge about the fact that she's lonely and doesn't have anybody else in her life. Contrast that with duress, which is really the application of force to get somebody to do something. So physical duress is really the easiest way for us to conceptualize duress. Think of holding a gun to somebody's head. Think of rubber hoses by police officers in Chicago in the 1930s, right? That type of physical duress occurs when a person makes a contract, enters into a contract to avoid harm to them or the threat of violence towards them. That agreement is voidable at the victim's election. Versus the concept of economic duress. So let's say you are a widget supplier and you have all these contracts coming up, but the person from whom you receive all of your widgets just quit, refuses to enter into the contract with you, and if you don't perform on these other widget contracts, you are going to lose your company. So it is a ride or die right now. Have to find other people to enter into contracts with so that you don't go bankrupt. Here's the deal. Courts recognize that you always have the option to walk away from a contract. Absent physical duress or threat of harm to you, you always have the option to walk away. And so it must be of such a significant potential threat of harm to you economically for courts to even contemplate economic duress as a defense to enforcing a contract. If you enter into a contract and you do it for economic reasons, the court assumes that you are entering into a contract after having done a cost-benefit analysis of what's better for you. And if that's entering into a predatory contract, chances are the court's not going to excuse your performance or undo the contract simply because of an economic duress defense. So that is the end of chapter 13. If you have any questions, feel free to email me, and otherwise I will see you guys in our next lab. Thanks.